Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Afternoon, Ms. Falk, Ms. Kemp.
Good afternoon.
Ms. Bridgewater, good afternoon. Good to see you.
Good to see you.
The SAP reset date is,
October the 25th.
okay, thank you. And it looks like we are waiting for the jail. Good afternoon.
Good afternoon, Carol. How you doing?
Doing well. Hope you are too.
I am, thank you.
Good. Who do we have?
This is gonna be position 7, Ms. Jackson.
Is this Zarakia Jackson?
Yes, it is.
Thank you.
Good afternoon, Ms. Jackson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006836C with 2 counts of simple battery. Is there a history, Mr. Howard?
What's the name?
Position 7, Ms. Jackson.
This is a 5th arrest. She has a hold out of the cab for arson. Last arrest was September 24th. Crossing county guard lines with drugs, weapons. That's open in Clayton County. 2020, negotiating fictitious checks. That was dismissed. April arrest, possession of drug-related objects. Sale of marijuana. Possession of a knife or a firearm during the commission. And possession of controlled substance with intent to distribute. That appears to be open as well. That's it.
Good afternoon, Ms. Vazquez.
Good afternoon, Your Honor. The state's recommendation on this case is going to be a $2,500 surety bond, $1,250.
This meeting is being recorded.
$1,250 on each count of simple battery. No further contact with the victims, Eddie Lynn and Tarnisha Lynn. Stay away from the incident location of 3787 MLK Junior Drive. 1-day anger awareness, no alcohol, drugs, or weapons, and ADET. This incident occurred on August 20th of this year. An officer responded to 3787 Martin Luther King Jr. Drive, Northwest Apartment F3 on a dispute call. One of the victims, Miss Tarnisha Lynn, told the police that her sister, who's the defendant, came to her home intoxicated. She said later in that day, the defendant started erratically jumping on her husband's lap. She began to kiss the husband, who's the other victim, Mr. Eddie Lynn, in his mouth by using her tongue. When Miss Lynn ordered her sister to leave, she stood up and she struck Mr. Lynn in his face with a closed fist. Then she approached her sister and struck her in the upper right arm before attempting to trip her and make her fall. Miss Lynn had to grab the defendant and put her out of their home. And she, I guess at the time of the incident, the sister had a broken leg and a cast on her foot. And so she kind of lost her balance. That for the basis, based on the open cases, Your Honor, and the nature of the offense, the state would ask that that surety bond and that no further contact be in place. Nothing further.
Mr. Lynch, is this your case?
Yes, Your Honor.
Okay, you can proceed.
So, Your Honor, my client is 42 years old. She is a lifelong Atlanta area resident. She does work. She works at the Clorox warehouse, where she's worked for the past 4 or 5 months. Before that, she was also working at Church's Chicken. She does have a 1-year-old, her granddaughter who lives with her, who she supports. She doesn't have a lot of finances in order at this point, which is one of the reasons we're going to ask Your Honor to consider a signature bond in this case. Ms. Jackson does not have any previous violent convictions. She does deny the basis of the allegations, and not to argue about what the facts may be. I think that will come out later in the case. But one allegation that was particularly concerning to her was what the solicitor mentioned about her sitting on one of the alleged victim's lap and tongue kissing her. My understanding is that person is like a brother to her, and she absolutely denies that took place. We're not going to get into why we think those allegations are being made in this point, but the point is that she strongly denies that and the other allegations put forward by the state. We would ask that you release her on her own recognizance and put her in a better position to be able to answer these charges. She will report to all court dates. I have contact for her. And so that's what we're asking the court in this case, Your Honor. Thank you.
All right. I'm going to release her to the hold. So it's going to be a $3,000 SOB through the jail on each count, which makes it a total of a $6,000 SOB through the jail. No further contact with Eddie and Tarnisha Lynn. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. I'm gonna let you out, Ms. Jackson, but if you do not show back for your next court hearing, then you'll be right back where you are, and there'll be a $6,000 bond at that point in time. Good luck to you, ma'am.
Thank you, sir.
Position 1, Boykin.
Good afternoon, Mr. Boykin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Boykin, you've been charged in case 22CR006832E with battery. Is there a history, Mr. Howard?
21 total. Last arrest was 2020, probation. Battery DV conviction, 2019. 2018 probation. 2016 probation. 2016 simple battery DV conviction. 2011 criminal damage to property conviction. And more probation. Got a 2010 simple battery terroristic threats. It just says bond over. That was out of Carrollton. More probation. You want me to stop?
You're good. Thank you. Good afternoon, Ms. Tortorella.
Good afternoon, Your Honor. If I may, I'm going to chat you in defense arrests involving this defendant and his history. I don't want to sound the charges. So I'm going to go ahead and send that to you and Ms. Gant.
Okay, thank you.
Okay, Your Honor. The state's recommending for this case a $6,000 surety bond. The conditions is no contact with the victim. Her name is Keyshawn Tucker. It's spelled Keysha, N as in Nancy, N as in Nancy A, Tucker, traditional spelling. 1 day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on June 30th, 2021 at 344 Westview Drive, Southwest in Atlanta. This defendant does pose a significant threat and danger to the person of Keyshawn Tucker. This incident occurred inside a vehicle. Officer D. Castro of the Atlanta Police Department responded to the incident location in reference to a domestic dispute. The defendant, Tyrone Boykin, did commit the act of punching Ms. Tucker in the head with a closed fist while stopped at a traffic light. As a result, Ms. Tucker jumped out of the vehicle and scraped her knee. Ms. Tucker did receive minor scrapes, bruises, and discoloration of her skin due to the battery. Ms. Tucker did receive medical attention on the scene from Grady EMS and was transported to Grady due to her pre-existing conditions with diabetes. The defendant was eventually arrested, and these events did occur in Fulton County, Georgia. Your Honor, as far as intimidation of the victim witness here, it's foreseeable due to the facts of this matter. And I want to stress to the court that the victim felt the need to jump out of a moving vehicle to protect herself from further harm. Also, Your Honor, this defendant has 21 cycles as stated by a pretrial. He's a convicted felon. He pled to battery family violence in 2020 out of Carroll County State Court. In 2011, he pled to criminal damage second degree to property second degree out of Carroll County Superior Court. I've already sent you the charges of arrests, Your Honor, that I do not want to sound out loud. Also in 2010, he was arrested for simple battery and terroristic threats by the Carrollton Police Department. He has various VOPs. His most recent one is in 2020 out of Carroll County that was revoked. And Your Honor, for this reason, we do believe a $6,000 surety bond is more than reasonable, given his history, the fact that he does have domestic violence history in his background, and the facts in this case. Nothing further.
Thank you, Ms. Tortorella. Ms. Gant?
Thank you, Your Honor. Mr. Tyrone Boykin is 43 years old. He has been in Georgia his entire life. He's actually a resident of Carrington, Georgia, which is about 1 hour away. He does have a sister in Atlanta, and he also has 2 children, ages 14 and 21. Mr. Boykin completed high school. He is actually currently employed at an auto parts manufacturer. He states that he just got this job and that he had been employed for about 8 months prior to getting this new job. So he's really anxious to get out. He denies the allegations, and I do acknowledge my client's history, Your Honor. However, I would just counter some of the state's arguments. I would bring to the court's attention that this incident is alleged to have occurred back in June of 2021. That is well over a year ago. My client maintains that he has not been in contact with Ms. Tucker, nor does he want to have contact with her. Therefore, I do believe that the state's concerns regarding Mr. Boykin posing a significant threat of danger or and intimidating the witnesses are unfounded. I am requesting a signature bond on Mr. Boykin's behalf. If Your Honor determines that he is ineligible, then I would ask for a more reasonable bond, given his inability to pay and he doesn't have anyone to call. I would ask for a bond of no more than $2,000, Your Honor. And again, we are unopposed to any stay away and no contact provisions. And the complaining witness and my client do not share any children, so we're not requesting third-party transfer. Thank you, Your Honor.
It's going to be a $4,000 good bond, no further contact with Kashana Tucker, stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Boykin.
Thank you, Your Honor.
Position 2, Bradley.
Good afternoon, Mr. Bradley. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Bradley, you've been charged in case 22 CR 006841F with battery. Is there a history, Mr. Howard?
Second arrest, 07 resisting arrest.
Ms. Tortorella?
Yes, Your Honor. The state's asking for the $2,000 surety bond to increase to a $4,000 surety. No contact with the victim, and her name is Shayna Wheel, I'm sorry, and it's spelled SHAIN as in Nancy A. Last name is W as in water, IE, L as in log, and she's in the Zoom call, Your Honor. To stay away from the 410 Alexander Road address, apartment 641 in Atlanta. 1-day anger management, AA, no drugs or alcohol, no weapons, and no violations of Georgia law. Your Honor, this case occurred on March 9th, 2022 at the 3410 Alexander Road address in Atlanta. This defendant does pose a significant threat and danger to the person of Shayna Wheel. On March 30th, 2022, victim Ms. Wheel came to the Atlanta Police Department to report that her ex-boyfriend, defendant James Bradley, had assaulted her on March 9th of 2022. Ms. Wheel advised to investigator Stroner that the defendant choked her, threw her around the elevator at her own apartment complex. Ms. Wheel had pictures of the injuries to her neck, and she had swelling under her eye. The defendant had arrived intoxicated to the incident location, and he was advised to leave by Ms. Wheel, and that is when the incident occurred. She went in the elevator with the defendant, and he grabbed her by the neck of her hoodie. The defendant then threw her around the elevator using the now tightened hoodie collar as a physical leverage to throw the victim around. The defendant was eventually arrested, and all these events occurred in Fulton County, Georgia. Your Honor, as far as intimidation of the victim witness in this matter, it's foreseeable due to the facts of this case. The victim advised the officer she had broken off the relationship due to his alcoholism, and that he in fact gets angry when he drinks. The night of the incident, the defendant was intoxicated. And it's foreseeable the defendant will have another drunken episode, come back to the incident location and harass and or harm the victim, Your Honor. The state does fear this, and we are asking for that no contact. He has one cycle, Your Honor, in Georgia and one cycle out of Ohio. That makes him a multi-state offender. And we were able to speak to the victim. She did advise us that she was choked twice. And one of those instances, Your Honor, she was not able to breathe. We're going to look into that matter. But for this case, Your Honor, I understand is light criminal history, but the facts of this case are very concerning. We are asking for that $2,000 surety to increase to $4,000. Nothing further.
Ms. Gant.
Thank you, Your Honor. Before I proceed with my argument, I do not believe or would request to have a date for this offense out of Ohio. And that is directed to ASG Tortorello.
Yes, Attorney Gant, let me look up your client's information as criminal history.
And I will proceed, Your Honor. Mr. Bradley is 36 years old. He has been in the Atlanta, Georgia area since January of 2012. He has a 9-year-old daughter, and he is paying child support. And he does not share that child with Ms. Will. Mr. Bradley also has family here, including an aunt and an uncle. He graduated from Kent State University. He has a degree in business communications. He's also active in the community with St. Jude's through his fraternity, Kappa Alpha Psi. He is employed. He works at a local software marketing company, and he states that he was just promoted to a senior customer success manager back in August of 2022. My client strongly denies the allegations, and I would just bring to the court's attention that, again, this incident occurred back in March of 2022. My client informed me that he, in fact, is the person who ended the relationship with Ms. Will. He was trying to leave. She kept blocking the door and resisted him leaving. She stated he is adamant that he never physically touched her. I would bring to the court's attention that although it is within the complaining witness's prerogative to either go to the police or to not go, but I would just bring to the court's attention that the alleged date of the incident is March 9th. However, this incident was reported 21 days later, Your Honor, regarding the state's contentions that my client are a significant threat to Ms. Will, and that he will intimidate her and that he will commit offenses in the future. It's unfounded, Your Honor. My client has no history of violence whatsoever. He is presumed innocent. In this matter, he is recommended for a signature bond. I'm requesting a signature bond on his behalf, Your Honor. And if Your Honor determines that he's ineligible, then I would ask for a reasonable bond of no more than $1,000.
And just to inform the court and Miss Attorney Gant, he was arrested on January 7th, 2007 for resisting arrest out of Ohio. And as far as him and not intimidating the witness being unfounded, Your Honor, I don't, the state does not feel that that's accurate. Just based on the facts of this matter, Your Honor, he attacked her inside an elevator and flung her around like a rag doll, Your Honor. So for that reason, we do feel that $4,000 surety bond is more than justifiable. And we are also considering his light record, but we're also strongly considering the facts of this case. Nothing further.
And Your Honor, if I may, my client enjoys the presumption of innocence, okay? I mean, I apologize. He enjoys the presumption of innocence. He denies the allegations. He's offered a competing version. The state's contention that he's a multi-state offender is totally unfounded. As I recall hearing from pretrial, this is his second arrest. The first arrest was in 2007. That is quite remote. So again, for these reasons, I am asking for, again, the signature bond. And my client, if I didn't state before, he is unopposed to any no contact and stay away conditions. He maintains that he does not want to have contact with the complaining witness. Thank you, Your Honor.
Your Honor, the victim's on the line.
I see her, Ms. Tortorella was just about to acknowledge her. Ms. Will, if you would like to address the court, this is your opportunity to do so. You do not have to address the court, but if you would like to address the court, I'll need for you to activate your camera, unmute yourself for me, ma'am, and raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
I do want to acknowledge his attorney saying that I blocked the door when that's conflicting. I asked him to leave that night. He was extremely angry and erratic, and he started making disparaging remarks about my family in an attempt to get a rise out of me. So I had asked him to leave. Unfortunately, I did have to go downstairs with him because he had a parking pass of mine. And so in the elevator, just a quick correction, he was talking over me and towering over me, which is something that he had did a few times. And I had asked him not to do that. And so when I kind of blocked him from being in my face, he put his hands around my neck in the elevator and pushed me into the wall of the elevator and choked me. It wasn't until somebody came into the elevator that he stopped. When we got down to the second floor garage where his car was parked, he threw my parking pass into the garage. I picked it up. I had something of his that I wanted to throw into his car. And that is when he lunged at me. And that's when he grabbed my head and he tightened it and flung me around to the point where my glasses fell off. I do have text messages from that night and the next morning where I texted his friend. His friend actually called me that evening asking me if I was okay, what was going on, because he had called his friend yelling, excuse my language, I should have killed that bitch multiple times. So his friend called me to check on me to make sure I was okay. And then the next morning you will see text messages to his friend saying, with photos of my neck, of the incident, as well as asking him, like, should I go to the police? This is crazy. And his friend acknowledging what happened. And I believe the state should have screenshots of those text messages. I'm happy to send those again. And that's what happened there. I was fearful for my life that night. He was really erratic and angry, and I was trying my best not to engage him because I knew that there was just no stopping him. I did also speak to the mother of his child, and she did mention to me that he had did the same thing to her.
Objection, Your Honor, relevance. It's outside the scope.
Your Honor, just tell me what happened to you that night, ma'am.
Okay.
And Your Honor, just the state's objecting under 17-17-1, section 4, the victim is allowed to speak, and it doesn't restrict what she is allowed to speak in the hearings. Nothing further.
All right. Well, I'm restricting what she is allowed to say during this bond hearing. Go ahead, ma'am.
That's okay. Thank you, Your Honor. But yes, basically that was pretty much it that night. In terms of me not going to the police till 21 days later, I was extremely distraught. Something like this has never happened to me before. I didn't know how to handle it. When speaking to the prosecutor and the officer, both times I said I was so numb to what had happened that night that I just went home and washed my dishes. And as I continued to think about it, I said I had to stand up for myself and report this to the police because this was an assault on my life. So especially because he had mentioned to his friend that third night, I should have killed that bitch. And I believe that had he had his weapon on him, I would probably not be here. So
Thank you, ma'am. I appreciate.
Your Honor, the state does have questions for.
Objection, Your Honor. Objection. The complaining witness has testified extensively.
I'm going to allow Ms. Tortorella to ask a question. We do that in this court. Go ahead, Ms. Tortorella.
Thank you, Your Honor. Ms. Wheel, how are you?
I am okay today.
That's good. I just wanted to ask you, are you in fear of your safety from this defendant?
Not on a daily basis. I am in fear of retaliation, especially if he gets drunk, because he did call me a few weeks afterwards for something that angered him and harassed me that night. I have a recording of that call too, if that's needed, where I had then texted him that asking him to never contact me again because he choked me.
And are you aware of other violence from the defendant?
Objection, Your Honor.
It's relevant, Your Honor. It's definitely if it pertains to her.
Well, if not if it's hearsay, it's not Ms. Tortorella. If she has direct knowledge, then I'm going to allow her to say direct knowledge, but not somebody else has told her.
And just to put on the record, Your Honor, hearsay is allowed in bond hearings.
Okay, well, it's not going to be allowed in this bond hearing. Go ahead, Ms.
I do have direct knowledge from someone who his daughter's mother, who mentioned a very similar incident to me, because I had texted her a week afterwards because I was very close to his daughter. So to just let her know that I wouldn't be contacting her daughter and I didn't want their daughter to be upset and think that it was her fault. And the first thing she mentioned to me was, I hate that you went through the same thing I did 10 years ago when I was 38 weeks pregnant.
Thank you, Ms. Wheel. Thank you for your testimony today.
Anything further, Ms. Will?
No, I have nothing else. Thank
Okay.
you.
And
You're welcome.
Your Honor, if I may, I would just, I had a chance to review the warrant. I believe that ASG Tortorello indicated to this court that the complaining witness had some issues breathing. However, the very last sentence of the warrant, Your Honor, reads that she stated she did not lose air or impeded from breathing. The last thing, Your Honor, I neglected to object to any conditions that require my client to attend Alcoholics Anonymous. Again, these are allegations. My client is presumed innocent, and the complaining witness, frankly, isn't competent to testify whether or not Mr. Bradley needs AA. And again, I would just bring to the court's attention that my client is gainfully employed. This incident is alleged to have occurred in March of 2022. He was promoted at his job on August 22nd. So it's inconceivable that this person is such a drunk that he can't even function daily.
And Your Honor, just to respond to Attorney Gaines, what she just stated on record, yes, in the four corners of the warrant, that's what that states, that she did not, that she was able to breathe after she was strangled. However, Your Honor, again, I also stated this on record, we did speak to the victim and she herself told us that she was choked not once but twice, as she also stated it on record, and it was one of those strangulations where she was unable to breathe, and we're reviewing this as a felony review in our office.
And the last thing that I'll say to ASG's point, to her point, is that the warrant is the complaining witness gave her statement back to the police in March. I believe that is a better reflection of what actually happened as opposed to what the ASG gleaned from this interview that likely occurred just today, months later. Nothing further, Your Honor.
Okay, I'm gonna leave the bond where it is. It's a $2,000 good bond. No further contact with Ms. Wills. Stay away from the 410 Alex Road address. No drugs, alcohol, or weapons while out on bond. Mr. Bradley, let me make clear to you what no contact means. No contact means no contact whatsoever. No personal contact, no phone contact, no email contact, no social media contact. No contact whatsoever. If you do contact Ms. Will, you will be in violation of this bond, and you will be right back where you are. You understand?
I understand, Your Honor.
All right. Good luck to you, Mr. Bradley. You also, Ms. Will.
Thank you.
Who do we have next?
Position 3, Calhoun.
Good afternoon, Mr. Calhoun. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. You agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Calhoun, you've been charged in case 22 CR 006833J with battery, family violence, and criminal trespass. Is there a history, Mr. Howard?
7 total. Last arrest was 2020 battery DV. It was non-process. 2019 possession of cocaine, misdemeanor obstruction arrest. 2016 stalking NOLO. 2015 burglary in the first. Criminal damage of property, second degree conviction. 2014 FTAs for theft by receiving, obstruction, entering auto, and theft of mislaid property. He was convicted for the entering auto and obstruction in 2014. That's it.
Okay, thank you. Ms. Portorello?
Yes, Your Honor. The state's recommending a $10,000 surety bond. The conditions is no contact with the victim, Amanda Grimsley. Last name is Gri, M as in Mary, Sley. For the defendant to stay away from the incident location at 1124 Cascade Road Southwest in Atlanta. One day anger management, BHET, a third-party transfer of child only if the defendant's able to show proof of legitimization, no drugs or alcohol, no weapons, and no violations of Georgia law. Your Honor, this defendant has a risk of intimidating the victim in this case, and a risk of reoffending. He has prior difficulties with his victim, Your Honor. That battery family violence case that was just stated by pretrial 20 CR 004005G. The offense date was June 29th, 2020. The defendant punched Ms. Grimsley in the face and stomped her in the head. This was dismissed by the state because Ms. Grimsley came to the court and asked the state for it to be dismissed, Your Honor. The state will not be dismissing this case, even though the victim, just wanted to state this on record, we will not be dismissing it because of the victim will ask us to, Your Honor. This incident occurred on October 10th, 2022 at 1124 Cascade Road Southwest in Atlanta. The officers responded to a domestic call and spoke with the victim, Ms. Grimsley, who advised when she got home, her boyfriend, defendant Junius Calhoun, was already in the house and eventually began to argue with her. The defendant started throwing food items at Ms. Grimsley and around the house. The defendant then punched, kicked, and slung Ms. Grimsley by her hair around the living room area. The officer described that the room looked like a tornado went through it. The floor was wet with water and it had several items that appeared to have been thrown on the floor. The defendant confessed to the officer that he had thrown the items around. The officer observed Ms. Grimsley's shirt to be torn on one side of her shoulder. The defendant had ripped Miss Grimsley's shirt during the physical altercation. Miss Cherry Jackson, a friend and witness to the incident, was present during the altercation, and her statements corroborated with that of Miss Grimsley's. The officer observed scratches on Miss Grimsley's person. The defendant and the victim have lived together in the past, and the defendant was arrested, and all these events occurred in Fulton County, Georgia. Your Honor, it's foreseeable that this defendant will intimidate the victim here due to the facts of this case, the fact that they have prior difficulties. The defendant won't stop harming this victim. The fact that he did not care, he had witnesses present at the apartment. The defendant had also been drinking with friends when the victim arrived. He has 6 cycles, Your Honor. He's a convicted felon. He was convicted of aggravated stalking, reduced to stalking, and a criminal trespass. The burglary was dismissed by the DA's office. He actually, let me perfect the record, Your Honor. He pled no low contendere to that in Fulton Superior Court. In 2015, he was convicted of criminal damage to property 2nd degree out of Fulton County Superior Court. And in 2014, he was convicted of entering auto out of Fulton County Superior Court. And Your Honor, the victim was able to speak to us. We did make contact with her. She said that she and the defendant are in a relationship. They live together and they share 1 child. The victim did confirm that the defendant punched and kicked her and slung her around by her hair and throwing items around. She does not want the police involved. She does want contact, Your Honor. She has expressed to us that she depends on this defendant. However, Your Honor, we are asking for that no contact, given the matter before the court and the prior history with this victim that the defendant has.
Excuse me, Ms. Tortorella, I apologize. Will somebody mute Ms. Jackson, please? Ms. Amanda Jackson, put her on mute. Thank you. I apologize, Ms. Tortorella.
It's okay. We're just asking for that $10,000 surety bond.
Thank you. Ms. Tortorella, in the 2020 incident, did your office require that Mr. Calhoun complete any type of diversion program before you dismissed that case?
No, Your Honor. And I can't state for sure, but the only thing the no pros order stated was that it was dismissed because the victim came to court and asked the state to dismiss.
Okay, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Junius Calhoun is 26 years old. He has been in the Atlanta, Georgia area his entire life, and he informed me that he does not have any children, Your Honor. Mr. Calhoun states that he completed high school. He is currently employed in construction and has been so for the past 2 years. He strongly denies the allegations. He denies making any physical contact with Ms. Grizzly, the complaining witness. Your Honor, I do believe that the $10,000 bond for this battery family violence charge is excessive, Your Honor. Mr. Calhoun, what that case against him in 2020, although it's the same complaining witness, that that case did not lead to a conviction, and Your Honor, again, should not rely on any arrests that have not led to convictions, Your Honor. We are requesting a signature bond on Mr. Calhoun's behalf. If Your Honor determines that he is ineligible, I would ask for a no bond. Would ask for a lower bond of no more than $1,000. We are unopposed to the no contact order, as my client declines contact at this time. We are not requesting any third-party transfer, again, as my client indicates that they do not share any children. The state has not set forth any basis whatsoever for its request for a BHET. Therefore, we are opposed to that. And lastly, Your Honor, any concerns regarding intimidating the witness or reoffending, even though my client is presumed innocent, should be taken care of by the court's orders for him to not have any contact and to stay away. Thank you, Your Honor.
And Your Honor, as far as BHET, the victim did inform us that he was not taking his medications. So during the time, around the time the incident occurred. So that's the reason why we're asking for somebody to go check up on him regarding that matter. And nothing further, Your Honor.
For the battery family violence, it's going to be a $3,000 good bond. For the criminal trespass, a $500 good bond, making it a total of a $3,500 good bond. No further contact with the Amanda Grimsley. Stay away from 1124 Cascade Road. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Calhoun.
Thank you, Your Honor.
Position
Sure.
6, Holt.
Good afternoon, Mr. Holt. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006835C with theft by shoplifting. Is there a history, Mr. Howard?
36 total. Last arrest was in June, probation. He got an open burglary, smash and grab, possession of drug-related objects, giving false name and obstruction. It's 20 CP 194408. Got an open burglary in the second degree, 20 CP 194671. He got 5 probation violations in his history. He went to felony earlier. He got no bond. I got obstruction convictions from 2019, along with giving false name, simple battery, family violence. 2016 shoplifting conviction. 2018 failure to appear, identity theft, fraud. He was convicted later on in 2017 for identity theft. 2016 simple assault battery conviction. 2016 battery, no pros. 2015 disorderly conduct conviction. And he got an ag assault and battery conviction.
Good, Mr. Howard. What did he go to felony for today? What charge?
I see 2 counts of burglary in the second. Actually 3 counts. 2 counts of criminal damage to property, second degree.
All right, thank you. Ms. Vazquez?
Yes, Your Honor. Just in addition to that, I would add he also has a 2021 burglary, which he's out on bond for out of DeKalb, and that case number is D0283683. This incident occurred on September 24th of this year. An officer was working an extra job at Publix, located at 1001 Ponce de Leon Avenue.
Excuse me, Ms. Vazquez, I apologize. Mr. Holt, put your hand down, please. We'll be with you in turn, all right? Your counsel sees that you have your hand up. I apologize, Ms. Vazquez. Go ahead.
No, it's okay. When he was, the extra job officer was informed by an employee that there was a shoplifter leaving the store. The camera inside the grocery store was able to capture the image of a male entering the store, walking to the aisle, taking items and putting it in his bag. He went to the meat aisle and he put around the report said around 9 to 11 pre-wrapped packs of meat into his bag, which cost approximately $200, and then rushed out of the store. And they recognized him as a repeat shoplifter from that location. Your Honor, just based on all of the open cases, all of the history, the probation violations, he does not respond properly to legal process. He continues to reoffend, and so the state is asking for a $2,500 surety bond. Stay away from the incident location, again, which is at Publix at 1001 Ponce de Leon Avenue, theft class, and no alcohol, drugs, or weapons while out on bond. Nothing further.
Mr. Lynch?
Your Honor, my client's 51 years old. He has lived in the Atlanta area for, I believe, around 30 years from speaking to him. He is currently homeless, although he does have a mailing address that he has access to. He does suffer from several chronic disabilities. That's the total of his income. So in this case, really any bond is almost 10 amount to no bond. But Your Honor, if you were to determine he's not eligible for a signature bond, we would ask that you set a reasonable bond, perhaps around a $1,000 surety bond in this case.
All right, your client has his hand up. Mr. Lynch, Mr. Holt, you have the right to remain silent. Anything you say can be used against you. Mr. Lynch is here speaking on your behalf. If you need to speak with him, I'm happy to give you that opportunity, but I'm sure that he would advise you that it's probably best for you to remain silent, but that's up to you and Mr. Lynch. Mr. Lynch?
I would reiterate the caution that the judge just gave you. Mr. Holt, anything you say in this hearing can be used against you. And again, this hearing is not to try the facts based on evidence. I would strongly caution you against making any statements, and just understand that they could be used against you. And we can speak further about this case. I will come to visit you in jail, and we can have a private conversation. That's all I can say.
I'd rather speak, sir.
All right, Mr. Holt, again, you have the right to remain silent. Quite often people think that, put your hand, you can put your hand down, so I'm talking to you. That what they say to is going to help their situation, and quite often it doesn't. But over the advice of counsel, if you want to address the court, go ahead.
Yes, I've been in federal court earlier. I have no bond on 2 cases. I have 2 open cases. And I asked for help. I told them that I needed help, and I wanted someone to help me. So the judge gonna have a counselor and someone come out here to meet with me so I can get help. So far as what happened in this case right here.
Okay, Mr. Holt, I don't want you talking about what happened, okay?
I'm not talking what happened. I said, far as what happening now here on screen is the miscommunication for the shoplifting. I have greater issues that I'm dealing with within myself of trying to get help than anything far greater than this. So I'm asking that this y'all come together with whatever going on in the other courtroom, that I can get some help for my drug abuse, my alcoholism. That's more important to me than what everybody talking about.
Okay. Well, I hope that you get the help that you need, and in that regard, Mr. Holt, as far as this matter goes, it's going to be $1,000 good bond. You're to stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. I hope that you're able to get some help with those other cases, through those other cases that you're dealing with, okay?
Yes, sir.
All right. Good luck to you, Mr. Holt.
Position
Thank you very
4,
much.
Chavez.
May I be excused?
Are you done, Mr. Lynch?
Yes, Your Honor.
Okay. Have a good day.
You too, thanks.
I'm sorry, Your Honor, and you said $1,000 good bond?
That's correct.
And what were the other conditions? My apologies.
Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond.
Thank you.
Okay, you're welcome. I'm sorry, courtroom 2. Who do we have next?
Position 4, Chavez.
Good afternoon, Mr. Chavez Vazquez. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. You have been charged in case 22 CR 006834Y with 2 counts of theft by taking. Is there a history, Mr. Howard?
7 total. Last arrest was in May for theft by taking. June 2021, theft by taking. You got an open shoplifting in state court. It's 22 CR 001474Y. Theft by taking, 22 CR 002692D. He's on probation for burglary and ag assault. 2018, they gave him 10 years probation. He went to felony as well earlier for burglary. He got no bond on that. 2017, simple assault, no load. 2017, failure to appear. And a trespass that was dismissed from 2017.
Thank you, Mr. Howard. Ms. Tortorella?
Yes, Your Honor, for the 1 count, the first count of theft by taking, $2,000 surety bond. For the second count, the state's also recommending the same amount, a $2,000 surety, which would be a total of $4,000 surety bond. The conditions is no contact with the victims. Their names, Zachary Cannon, traditional spelling for both first and last, and Christine White. The first name is spelled Kristine. To stay away from the incident location at 880 Holcomb Bridge Road in Roswell. 1 minute. An anti-theft class, BHET, no drugs or alcohol, no weapons, and no violations of Georgia law. Your Honor, this defendant does pose a threat and danger to property of any person, a risk of reoffending and committing felonies while he's out on bond, and he is a flight risk. As you've heard, Your Honor, he's just been booked in for burglary, 22 CP 213085. He has no bond, and that offense date was June 9th, 2022. He has an open theft by taking case, 22 CR 002692D. The offense date was May 2nd, 2022. He was granted a $3,000 signature bond through the jail by Your Honor on March 3rd, 2022, where it was ordered in the bond order that he have no new violations of Georgia law. He is in direct violation of this bond order due to this case, Your Honor, and his open burglary case. This incident occurred on May 26, 2022 at 880 Holcomb Bridge Road. Officer Fields of the Roswell Police Department was dispatched to 12002 Jack Drive in Roswell in Fulton County in reference to a wellness check on a male subject identified as the defendant Carlos Chavez Vazquez, who was walking around the location with no shirt or shoes on and seemed lost. When the officer arrived to the incident location, he found the defendant fully clothed and holding a large bag of food in hand. The officer observed the defendant to be extremely disoriented. He seemed very nervous and was not able to hold a conversation. AMR came to the scene and asked him basic questions and checked up on the defendant. The defendant gave consent for police to search his bag for weapons. Police found a cell phone in the bag, and the defendant placed the cell phone in his right pocket. As the officer continued looking through the bag, he noticed there was a cooler inside and an ice pack in it. Defendant grabbed a name tag. He grabbed a name tag and key from the bag, and the officer took notice of that and saw that the name tag had the name of Zach Cannon, and the key had an address on it. The officer was able to make contact with Mr. Cannon, who advised the officer his name tag was gone along with his black book bag, which had a small lunch cooler in it. He stated that he had it outside of the office, which is located at 880 Holcomb Bridge Road. And when he went out to grab his bag, it was gone. The defendant was released to his mother, Anna Chavez, who came to pick him up. A few minutes after the defendant left the incident location with his mother, a female identified as Kristen West came over to the location and stated that her phone had been stolen from the incident location, and it was pinging at the current location the officer was at. Ms. West described the phone to the officer, and the phone described by the victim was the exact match of the phone that was in the backpack, and where the defendant placed it in his right pocket before he left. Ms. West gave a description to the officer which matched the identity of the defendant. Officer then called defendant's mother, Ms. Chavez, that he did not come back and return the cell phone, that he would be charging him with theft by taking. The defendant never returned, and defendant was charged. Both items taken by the defendant were less than $1,500, and this all occurred in Fulton County, Georgia. Your Honor, he has 8 cycles. He was convicted of theft by taking in 2021 at a Fulton County State Court. He was convicted of, he pled under the first offender for aggravated assault and burglary in Fulton County Superior Court in 2018. He was convicted of simple assault. Well, I'm sorry, again, let me perfect the record. He pled nolo to simple assault at Fulton State Court in 2017. Your Honor, he does have some theft history. He has several open theft cases in state court, and one currently right now in Superior Court. So for that reason, we do feel $4,000 surety bond is more than reasonable, not to mention the fact that he's violated his bond order from the previous case. Nothing further.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Carlos Chavez Vazquez is 23 years old. He has been in the Atlanta, Georgia area his entire life. He does not have any children. He completed the 10th grade, and he is currently employed as a painter. He states that he has been working in this capacity for the past 2 years. Your Honor, Mr. Chavez Vazquez denies the allegations. He is presumed innocent. Regarding bond, Your Honor, I'm requesting a signature bond. If Your Honor determines that he's ineligible, then I would ask for a low bond, bond of no more than $1,000 for each count of theft, for a total of $2,000. We are unopposed to any no contact and stay away provisions. We are opposed to the anti-theft class. As we heard from pretrial, Mr. Chavez is being held without bond. It is likely that he will lose his job. The date of his discharge is unknown, so we do not want to put him in the position to violate a bond condition by the court's order to attend an anti-theft class. The state has put forth no basis to suggest that Mr. Chavez Vazquez should be evaluated for BHET. Again, this incident occurred back in May of 2022. I had the luxury of interviewing Mr. Chavez Vazquez. I do not have any concerns regarding his competency, which is the heart of what's important. And finally, Your Honor, to Ms. Tortorello's contentions that Mr. Chavez Vazquez is a threat of danger to property and that he's a flight risk, I would just bring to the court's attention, as we heard, he did not receive any bond. Therefore, he's not going anywhere and he's not a threat to anyone in the community, Your Honor. Thank you.
It's going to be $1,000 good bond for each charge, making it for a total of a $2,000 good bond. No further contact with Mr. Cannon and Ms. White. Stay away from the Holcomb Bridge Road address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Chavez Vazquez.
Thank you, Your Honor.
You're done. Position 5, Ford.
Good afternoon, Mr. Ford. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Can you hear me, Mr. Ford?
Yes, sir.
Okay, and you agree to have this done by video?
Yes.
Okay, thank you, sir. Mr. Ford, you've been charged in case 22 CR 006842Y with criminal trespass. Is there a history, Mr. Howard?
68 total between Georgia and Texas. Last arrest was 2021 on a CWAC. It was not presented to grand jury. March 2021, shoplifting. He went to the city jail for that. Another March 2021, possession of drug-related objects. December 2020, shoplifting arrest. November 2020, shoplifting arrest. 2020, theft by taking, 2 counts. Conviction, that was out of state court. It was a simple battery with that arrest. I don't see it on the disposition. 2019, simple battery, trespass, pled nolo. 2019, probation. 2019, trespass, conviction. 2018, possession of cocaine. 2016, probation. 2015, obstruction, trespass, felony terroristic threats. Interference with government property, simple assault.
Okay.
All those were convictions.
Thank you, Mr. Howard. Ms. Bacchus?
Yes, Your Honor. The state is recommending a $500 surety bond. Stay away from the incident location, which is the Publix located at 2020 Howell Mill Road. And no alcohol, drugs, or weapons while out on bond. This incident occurred yesterday. The defendant has been criminally trespassed from that incident location numerous times for stealing. And despite that, he returned to the property yesterday. And when asked to leave, he refused to leave. Your Honor, the biggest concern with this individual is the repeat offenses. He has so many, I can't even count. There's so many criminal trespasses on his history. And so because there is the likelihood of reoffense, that is why we're asking that $500 surety bond be put into place. Nothing further.
Thank you. Ms. Gann, is he residentially challenged?
Yes, Your Honor.
Okay, you can go ahead.
Your Honor, if the defense has resources that they're able to offer that would be of help for that purpose, that would be great for the state and the defense and for the defendant.
Thank you, Ms. Bacchus. Ms. Gann?
Thank you, Your Honor. Mr. Isaiah Ford is 57 years old. He has been in the Atlanta, Georgia area his entire life. He does not have any children, He completed the 12th grade, and as Your Honor just heard, he is residentially challenged and has been unemployed for a long period of time. He denies the allegations. He is presumed innocent. I am requesting a signature bond on Mr. Ford's behalf. If Your Honor determines that he's ineligible, then I am unopposed to the bond recommendation of the state. We are unopposed to the stay away. And of course, as always, I am happy to enter a consult, as I discussed with Mr. Ford, to help with some of his social issues, Your Honor. Thank you.
Okay, thank you, Ms. Gann. I would like to have a social worker visit him. It's going to be a $500 good bond, stay away from that Publix, and no drugs, alcohol, weapons while out on bond. Would you please make sure that when he comes to the SAP that he doesn't fall through the, if he comes to the SAP, that he doesn't fall through the cracks, so that I can address him again. Then we had somebody today who I'd asked for there to be a social worker visit for, and it was not accomplished, so I couldn't do anything with them. So although I try to help, if you all could help me just by passing it along and making sure that those that need someone to go assist them, that within that 2-week period that's accomplished, I'd greatly appreciate that. Okay.
Thank you. Thank you for bringing it to our attention.
Thank you. Good luck to you, Mr. Ford.
And Your Honor, if I may, this concludes my business. May I be excused?
Yes, I'll see you next time, Ms. Gann. Thank you.
Thank you.
Position 8, Low.
Good afternoon, Mr. Lowe. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You agree to have your case heard by video?
Yes, sir, Judge.
Thank you. Mr. Lowe, you've been charged in case 22 CR 006843Y with simple battery against a police officer, criminal trespass, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
19 total. Last arrest was in June. Criminal damage to property, 2nd degree. Dismissed. 2019 simple battery conviction. 2018 shoplifting arrest. 2013 probation violation. Underlying charge was armed robbery. 09 SC 862667. 2013 trespass, disorderly conduct. 2012 misdemeanor possession of marijuana, NOLO. Got another probation violation, 2012 from that robbery. 2011 as well. 2010 trespass conviction, parole violation, and the 09 robbery conviction. That's it.
All right, Ms. Bacchus.
Yes, Your Honor. The state is recommending a $2,000 surety bond, $1,500 on the simple battery against an officer, and $250 on the other 2 charges. A stay away from the incident location, which is the Ideal Sports Bar located at 1953 Lakewood. No alcohol, drugs, or weapons while out on bond. This incident occurred on October 9th. An officer was dispatched to that incident location in reference to a criminal trespass. Upon arrival, the officer spoke with the bartender, Miss Kayla Gillum, who stated that she had asked the defendant to leave the establishment multiple times due to him smoking inside of the property. A witness on the scene also asked him multiple times to stop smoking, and that's when the defendant went over to the witness and started to put his hands inside of the witness's pockets. The officer confronted the defendant, also asked him to leave the property, and each time he asked, he basically said he wasn't going to leave because he had spent money inside of the establishment. At that time, the officer attempted to detain him and he resisted arrest, though he was eventually physically brought to the ground. The officer did note that he was intoxicated, and while taking him out of the patrol car, he started to fight the officer, became belligerent, saying he would beat the officer's ass. And lastly, he spit on the officer inside the jail. Your Honor, based on the repeat offenses, based on the nature of the offense, the belligerence and erratic behavior towards the officer, we are asking that a surety bond would be put in place for this defendant. Nothing further.
Ms. Kim.
Yes, Your Honor. Actually, he is recommended for unsecured judicial relief signature on bond. He is 38 years old and he has been here in Georgia all his life. And he has 13-year-old child that he has to take care of and pay for. He's employed as a JT home improvement. And indeed, he's been doing that for 2 months to 3 months. And tomorrow is the day that they start the new project, and he does not want to miss this out. He has to make money to take care of his family. He didn't graduate from high school. He did up to 10th grade, and this job is very important for him. We would like to request for signature on bond for all these 3 charges. And if Your Honor is not inclined to give him a signature on bond, we would like to recommend maximum $1,000 for good bond for willful obstruction, and the other one, 250 signature on bond through jail. Thanks.
Where's he working, Ms. Kim?
JT home improvement, Your Honor.
All right. It's going to be a $2,000 signature bond for the simple battery, $1,000 signature bond for the criminal trespass, and $1,000 signature bond for the willful obstruction. Makes it a $4,000 signature bond through the jail. Stay away from the Ideal Sports Bar, and no drugs, alcohol, or weapons while out on bond. Mr. Lowe, I'm letting you out because I want you to be able to work and take care of your family. But if you get into any more trouble, in this, you'll be right back where you are. And this bond will be no more. Okay. All right. Good luck to you, Mr. Lowe.
Thank you, Mr. Judge.
You're done. Position 10, Montgomery.
Good afternoon, Mr. Montgomery. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Mr. Montgomery, you've been charged in case 22 CR 0068408 with battery and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
16 total. Last arrest was in July. Battery DV, cruelty in the 3rd. 2018 battery DV out of Clayton County, pled NOLO. He was acquitted for simple battery, 2 counts, battery DV. 2017 out of Burnett. 2016 probation. 2016 battery DV, it was dismissed. Simple battery was dismissed as well. 2016 FTA for driving on suspended license. 2013 conviction for driving without a valid license. And 2010 probation for marijuana. That's it.
Ms. Duncan?
Yes, Your Honor. Good afternoon. I just wanted to add to the record as to what pretrial stated that July 22nd, 2022 case out of DeKalb County is with the same victim in today's case. That case number is 22S004555. In that case, the defendant was let out on a $5,700 good bond through a bonding company and received conditions to stay away from the victim and to attend a domestic violence class. As to this incident, Your Honor, the state is going to be requesting a $7,500 surety bond due to the continuing pattern of escalation and this defendant's extensive history with battery family violence matters. In this incident, it did occur on June 9, 2022 at 231 Greenhaven Drive Southeast in Atlanta. What's indicated from the facts, Your Honor, is that the defendant and the victim in this case, Ms. Quanisha Guthrie, that's Quanisha, last name Guthrie, were involved in a verbal altercation that was lasting all day and became physical when she returned home to confront him about going through her cellular phone. At the time when she was confronting him about going through his phone,
going through her phone, she tried to grab his to do the same thing. And when she did so, Your Honor, the defendant grabbed her by the throat with both hands and threw her onto the bed and got on top of her. The police report indicates that at that time, he did squeeze her neck, hindering her ability to breathe and speak. Additionally, he punched her in the left ear twice, causing her hearing hole to tear and bleed. She was able to eventually get the defendant off of her in that particular instance by fighting him off. However, when she got him off, she did grab his phone and throw it to the ground. And after she did that, he grabbed her again by the neck and threw her to the floor again. My apologies. And got on top of her again, placing those hands around her neck. At that time, he punched her in the nose and left eye. The victim did indicate to our victim advocate today that she did receive a bloody nose as a result of being punched in the face on that iteration. And she attempted to get away from him by kneeing him in the groin. She tried to escape the room by screaming for her daughter, minor MB. And her daughter came out of her room and saw the instance. And after she got out of the room, the defendant grabbed her again by the neck, threw her against the wall and down to the ground. And at that time, her daughter was able to run out of the home. It was indicated in the police report that he took her firearm in that instance. However, we've now learned that he brought it back. And that firearm is now in custody because it had to be used in the later incident to defend herself to the utmost against the defendant from attacking her again. We have a concern about the risk of reoffense, and here in the state thinks it's clear. There's obviously a continuing pattern of violence between these two parties, and the state has a concern about this defendant's flight risk, given that there is an FTA from 2016, as well as the likelihood of response to legal process. I did see a couple of probation violations in that GCIC as well. So we do believe that that $7,500 surety bond is more than reasonable in this case, and that would be $5,000 for the battery and $2,500 for the cruelty to children. We ask for no further contact with either of the victims in this case. A stay away. The victim did indicate that that location stated on record is her location. 2 weeks anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state, and I do believe that the victim is on the line if Your Honor would like to sound for her.
Thank you, Ms. Duncan. Ms. Kim?
Yes, may I please go first? Mr. Malcolm Montgomery, he is 33 years old, and he was born and raised here in Georgia. This is his native state. He has 2 children, 10 and 8 years old, and his family members all here in Georgia. Because of head injury that he suffered about 2 months ago, he has been unemployed, and his high school education was up to 11th grade. And this one happened on June 9, 2022. They do not live together. They have no children together. So there is no reason for my client to intimidate anybody else at all. We have no objection to stay away from 231 Green Place, and also no further contact with Quanisha and also MB, the minor. We would like to request for a signature on bond, and yet, if Your Honor is not inclined to give him a signature on bond because of a previous incident at DeKalb County, we would like to request for maximum $2,000, $1,000 per each charge. Thanks.
Ms. Guthrie, I see you there. If you would like to address the court, I'll need for you to raise your right hand, and I'll have to swear you in. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hand down, ma'am. What would you like to tell the court?
I did speak with someone this morning. I spoke with someone before this that I do not feel any threat with Malcolm. He has not contacted me since the last incident. I haven't heard from him. He doesn't live here. We do not have kids together. I did not want to pursue the case. She did mention that they didn't want to drop it, but I do feel safe, and he hasn't bothered me since the incident.
All right, thank you, ma'am. For the battery, it's going to be a $4,000 good bond. For the cruelty, a $1,000 good bond, making for a total of a $5,000 good bond. No further contact with Ms. Guthrie. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. All right,
Thank
good
you.
luck to you, Ms.
Thank
Linda.
you.
And Ms. Guthrie, you also.
Judge, what type of bond is it?
It's a good bond, 5,000 good, 4 for the battery, 1 for the cruelty.
And does it also include a no further contact with the minor?
Yes, and no further contact with the minor daughter.
Thank you.
I'll explain. Position 12, Young.
State is requesting a breakout room for this case, Your Honor.
Okay,
And Your Honor, if the state may ask that we preserve this one till the end, I also wanted to talk to the court about a matter that has been raised.
okay.
Thank you.
Matter that's been raised in Mr. Young's case?
No. In an unrelated matter, it's just the breakout would be an appropriate time to raise that.
Okay, all right.
Thank
So, can we take someone else and come back to Mr. Young at the end of the calendar?
Okay, Judge, we only have one more than him.
That's fine.
We're getting them out.
All right, and did someone bond out? I have Mr. Mapp and Mr.
Yes.
Pringle.
Mr. Matt got released and Mr. Pringle is. This is 11 Shringle.
Okay. Good afternoon, Mr. Pringle. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon, Judge.
Good afternoon, sir. You have been charged in case 22 CR 006837J with battery, family violence, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
I was looking at a warrant. Yeah, 6 total. Between Georgia and South Carolina. I'll give you South Carolina first. 2020 DUI conviction. 2019 DUI dismissed. 2019 another DUI conviction. 2016 resisting arrest. That's it as far as South Carolina. Yeah. Oh, that's it. So yeah, he got 4. This is 5th arrest, not 6. That's all I have. And he's a resident of Hardyville, South Carolina.
Okay, I understand.
Oh, and he's a fugitive from justice too. All right, that's it.
Okay.
That's what I was going to add. Thank you, Mr. Howard. This incident did occur on October 8, 2022 at 3420 Norman Berry Drive in Hateville, Woolton County. In this instance, the defendant got into a physical altercation with his child's mother and scratched her face and bit her breast. He resisted officers' commands to put his hands behind his back once he was arrested, so much so to the point where he tensed his arms and refused to walk without assistance to the patrol vehicle. And he also further refused to get into the patrol vehicle without assistance from the officers. Our office did not get a chance to speak to the victim in this case. We called the number, it was disconnected. We do have concerns in this case about the possible intimidation of the witness victim because they do share a child together. We also have concerns about this defendant's ties to the community. As pretrial stated, this defendant is a resident of South Carolina. And we also have concerns about this defendant being a flight risk, given that he currently has a fugitive from justice warrant out for him. In this case, Your Honor, we do believe that a $4,000 total surety is more than reasonable. That will be $3,500 for the battery, family violence, and $500 for the willful obstruction. We're going to be asking for a third-party contact with the child that they share together. Let's stay away from that incident location. One-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
What's the alleged victim's name?
Her name is, my apologies, Cheryl Denise Singleton, Sheryl, a middle name, common spelling, Singleton, common spelling.
Thank you. Ms. Kim?
Yes, Mr. Pringles is 28 years old, and of course, he lives in South Carolina. He was visiting here, and their incident happened at the hotel. Um, well, according to my client, they have lived on and off about 4 years as a dating couple. However, they broke up, so they're not going to be living together. And my client says he has no child together with her. So we don't think it is necessary to have a third party child transfer at this point. And he has a very good address and phone number in South Carolina, and it's only like 3.5 hours away from here by driving. So he will be coming back to take care of his matters. And by the way, he has to be anyway waiting for the foreign county, which is South Carolina, because there's a outstanding warrant out there, and he has to be transferred to that location anyway. So, but anyway, we would like to request for a signature on bond for this. However, if Your Honor is not inclined to give him a signature on bond, we ask for $1,000 maximum, total of $2,000 good bond.
And just to clear the record, Your Honor, the warrant did indicate that they share a child and live together at that incident location. Nothing further.
All right. Ms. Kim, your client has his hand up.
Mr. Pringle, I strongly recommend you to stay silent. You do not want to hurt your case. If you have any question, I'll give you a call so I can explain to you.
All right, it's gonna, for the battery, a $1,250 good bond. For the willful obstruction, a $250 good bond, making for a total of a $1,500 good bond. No further contact with Ms. Singleton, stay away from the Normanberry Drive address, and no drugs, alcohol, or weapons while out on bond.
Thanks, Your Honor.
Thank you, Your Honor.
Good luck to you, Mr. Pringle.
Thank you, Your Honor.
And you're welcome, sir. And before we go into the breakout room, could I get Mr. Young's history, Mr. Howard?
This is fourth arrest. Last arrest was in September. Public Peace out of Texas. Resident of Hitchcock, Texas. That appears to be open. Before that was a 2021 burglary of a building. Theft of property. The theft was a conviction. I think the burglary was reduced to theft. What else? 2021 March, driving while intoxicated with child under the age of 15 years of age. That was guilty. And the first cycle was a juvie. So that's all. And resident of Texas, like I said.
Okay, thank you. So who needs to be in this breakout room?
Myself, Ms. Falk, Ms. Kim.
All right, and Ms. Bridgewater. Okay, good afternoon, Mr. Young. We've had an opportunity to discuss your matter with counsel and the solicitor's office in this regard. You've been charged in case 22 CR 006838A with simple battery and criminal trespass. For the simple battery, it's going to be a $1,500 good bond. For the criminal trespass, a $500 good bond, making for a total of a $2,000 good bond. No further contact with the alleged victim, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Young.
All right, you can.
Okay, and I believe that completes everything. Is that correct?
Yes, that's correct, Judge.
All right, thank you. We appreciate it.
Okay. You're welcome. Have a good one. Thank you.
All right, thank you. So whenever Ms. Bridgewater is ready and
I'm ready. Okay, once again, the reset date for the SAP calendar is going to be October the 25th. Position number 1 is going to the SAP calendar with a $4,000 good bond. Position 2 also going to the SAP calendar with a $2,000 good bond. Position 3 to the SAP calendar with the $3,500 total good bond. Position 4 SAP calendar with a $2,000 total good bond. Position 5 SAP calendar with a $500 good bond. Position 6 SAP calendar with a $1,000 good bond. Position 7 is reset further notice with a $6,000 total SOB through the jail. Position 8 reset further notice with a $4,000 total SOB through the jail. Position number 9 is reset further notice as the defendant was released. Position 10 reset to the SAP calendar with a $5,000 total good bond. Position 11 is going to the SAP calendar with a $1,500 total good bond. And position 12, SAP calendar with a $2,000 total good bond. Are there any questions, comments, or otherwise? If not,
You may have already said this. My apologies. What was the SAP reset date?
October the 25th.
Okay, thank you so much.
You're welcome.
all right. You all have a good rest of the day, and I'll see you, I guess, next week.
Thank you, Your Honor. Have a good day.
All righty. Bye-bye.